Good afternoon, everyone, and welcome to our webinar, Reflections on the ADA, Past, Present, and Future. My name is Megan Jones. I am an office assistant at TransCen. We are pleased to be joined by John Welch and Marian Vessels today. John Welch is a disability rights attorney, socializing in Americans with Disabilities Act and the Convention of the Rights of Persons with Disabilities. He served 42 years in federal government, where he authored the government's compassionate disability rights regulation and created and led by the Department of Justice section in charge of enforcing the ADA. He has served as the Department of Justice Chief Technical Expert during the writing and passage of the ADA. He was then the Chief of Author of the Technical Assistance Programs and oversaw the Department's ADA enforcement efforts. He was responsible for this major revision of the accessible design. He is also the Chief Author of the first regulation implementing Section 504 of the Rehabilitation Act of 1973. As a member of the U.S. delegation to the United Nations, he assisted in the development of a vision on the rights of persons with disabilities. He now provides training and guidance on the ADA and continues work on the international level, assisting countries with their own disability rights law. He received a BA from Trinity College, an MPA from Harvard University, and a JD from the Georgetown University Law. Marian Vessels. Marian Vessels was the director of the Mid-Atlantic ADA Center from 1996 until she retired in 2016. She was the liaison with Entitled and Disability Coalition in the 6-state Mid-Atlantic region. She spearheaded the ADA National Network Hospitality Initiative. Her primary areas of interest are providing information, training, and guidance on the Americans with Disabilities Act and employment, state, and local government, the arts, and accessible customer service. Previously, she was the director of the Maryland's Governor Committee on Employment of People with Disabilities and the director of the Maryland's Governor on Disability. Now, I will now turn the program on to John and Marian.
Thank you, Megan, for that wonderful introduction. It's really my pleasure to be able to sit next to my friend John Wodatch and talk about something that I think both of us are very passionate about. And John has had extreme experience in developing not only the ADA regulations, but many others. We're going to be talking today about reflections of the ADA, past, present, and future. So you're going to learn a little bit about the history and where we see the ADA going. The perspectives obviously will be a little different in John writing regulations and my having the opportunity as a person with a disability to be able to live it and provide guidance to folks who have rights and responsibilities under the Americans with Disabilities Act. I'm going to turn it over to John to talk a little bit about the history prior to the beginning of the ADA.
Okay, thank you, Marian. I'm delighted to be here with you and with everyone watching and listening in. Let's start. I'd like to begin before the ADA, way before the ADA. Throughout U.S. history, even though almost every American family had a member or a friend with a disability, We were trapped in a culture of stereotypes and barriers, both attitudinal barriers and architectural barriers. This culture was reinforced by repressive and regressive state and local government actions, court decisions, and it was a fairly bleak time for people with disabilities who were isolated and segregated in our society and denied the ability to participate in most aspects of American life. This picture began changing in the 1960s and the 1970s. But even though it began changing, if we took a snapshot at that time, you would find very little accessible housing, very few accessible buildings, almost no public accessible restrooms in our cities and towns. Children with disabilities, if they are educated at all, were educated in separate inferior institutions. Very little accessible public transportation, very restrictive employment opportunities for people with disabilities. And people with disabilities who were really separated, were often separated from their families and housed in separate institutions that were underfunded and, in fact, warehouses. This began changing in the 60s. The first law that we saw was the Architectural Barriers Act of 1968 that applied to the federal government and the buildings it was building, whether they were building them themselves or providing grants or contracts for building them, and the Rehabilitation Act of 1973, which was the first federal effort to have a comprehensive civil rights law protecting the rights of people with disabilities. I hope you're all familiar with Section 504, which was the beginning of the change about how we saw people with disabilities. We're undergoing what social scientists call a paradigm shift. Instead of seeing people with disabilities as objects of charity, we were beginning to say, oh, wait a minute, people with disabilities are citizens of our country. They have rights. They are entitled to participate in all the activities of government. It was a beginning to look at empowering people with disabilities, to treat them with dignity, to give them opportunity to participate. Marian, do you want to comment on that brief period?
You know, many of us with disabilities were just starting to learn what the laws were. And we know Section 504 was never really well known or well enforced. And even today, there are still many people that don't know they have rights and responsibilities under Section 504. So it provided a good basis and background. When I was injured in a car accident in 1974, I didn't realize that there were laws at the time that really did protect me. And when I went back to school and college, did find that there were protections that I had, some. But I was incredibly frustrated at the lack of my ability to be independent as a wheelchair user, to be able to move around the community, to be able to determine if and when I could go places. What I had to do, it took tremendous amount of planning just to go out to dinner. We're so comfortable with cell phones now, being able to call and check things on the fly. But not having that ability, really, looking back now, I think we were kind of ostracized in so many ways. In the 60s and 70s, you didn't see people with disabilities out on the street much. You certainly didn't see them in general settings as much because it was very difficult, both with transportation, physical access, and lack of accommodations. You rarely saw sign language, braille, none of the things that we take for granted today, or becoming to take more for granted today, really existed in that time period. There were lots of political actions that happened around people with disabilities, as you said, demanding their rights as citizens, as taxpayers, as people who have the need to be educated, to be housed, to get medical care, to be able to recreate and shop with everyone else. And the beginning of the ADA really laid out by Section 504 really was a great foundation for us to work on.
Yeah, and during this period, during the 80s especially, a number of people were coming to the conclusion that Section 504 and the other parts of Title V of the Rehabilitation Act, Section 503 that applied to federal contracts, wasn't enough. And it wasn't enough for a couple of reasons. There was sporadic enforcement. There was no unit at the Justice Department or in most agencies that specialized on the rights of persons with disabilities. There was no focal point. Also, the nature of Section 504 itself applied to recipients of federal financial assistance. And so think of a police department. One year it might get federal funds, so it was covered by 504. The next year they might not have a grant, so there was no civil rights protection. There were wide parts of the business, employers, who didn't receive federal financial assistance, so there wasn't even coverage under the Rehabilitation Act for them. So the idea was we needed something. We needed a comprehensive law. And a number of factors came together, and I'd like to talk about what I think of as three concepts. I apologize, I'm a lawyer, I think of things in terms of concepts, that motivated what became the ADA, and these are what I would call parallelism, comprehensiveness, and incrementalism. Parallelism. The idea behind the ADA was a simple one. And a very powerful one, which was to give to people with disabilities, a wide group of people with disabilities, the same rights at the federal level that women in our society, that African Americans in our society, people of color had under the existing federal civil rights law, just to give people with disabilities the same fair shake that everyone else had. Very simple, powerful idea. So parallelism. And how you went about that was, and if you look at the ADA and you wonder how did it come about, why is it structured the way it is, people in Congress looked at the existing laws and said, okay, we will do for people with disabilities the same thing we did for others. So in employment, the Title VII of the Civil Rights Act provides protections on the basis of race, color, national origin, sex, religion. The idea, it applied to employers, public and private, who had 15 or more employees. Okay, we're going to do the same thing for the ADA. Title II of the Civil Rights Act of 1964 covered public accommodations. It had a list of public accommodations. It gave people a private right of action. Okay, we're going to do the same thing for public accommodations. So giving to people with disabilities the same kind of protections that our civil rights laws already had. The next idea that was a very important one was comprehensiveness. You had to have effective coverage, and it had to be broad coverage. So the idea was a simple one. Think of a person, okay, we want the person to be able to have a job. So you have to cover employment. How is the person going to get to the job? Wait a minute, you have to have some form of accessible transportation. Once the person has a job, what are they going to do in the evening? Can they go to the theater? Can they go to sporting events? Can they go to the neighborhood bar? So it's important, if we're talking comprehensiveness in our life, to cover those aspects of our life. It's also important to engage in your community, to live in your community, to be able to go to your local government, your state government, and participate in decisions that are made about you in the laws of our states and cities. And all of this wouldn't work without telecommunications being accessible. So the idea of comprehensiveness became a key feature of the ADA. We had to cover all those features of American life to give people with disabilities the ability to participate. And the last idea here is incrementalism, and by that you have to realize this was in 1990 when the ADA was being considered. This was a major change. We had a Republican administration that was at its heart a conservative administration, but very committed to the idea of a comprehensive law. President Bush, who was the first President Bush, had a campaign pledge that he would have a comprehensive law. And to get people to be comfortable about it, they were comfortable with Section 504, partly because there had been a lot of regulations in the 1980s. Under the Reagan administration, the Department of Justice and over 100 federal agencies had issued federal regulations. These 504 regulations had common language about the definition of what is a person with a disability and common language about what non-discrimination is. People in the disability community were comfortable with those regulations. They had fought to get them issued and enforced. And so the idea of using the 504 concepts for definition of person with a disability and for what constitutes discrimination were the ideas behind getting that language into the ADA itself.
Before we go on, we're going to change to slide 17, talking about leading up to the passage. The ADA wouldn't have come about without the activism of people with disabilities. We had the basis for some of the laws and the structure, some of the enforcement, but it really was people with disabilities who started demanding their rights as a citizen of the United States, just like everyone else. So we saw massive protests. We saw sit-ins under Section 504 in San Francisco. We saw people climbing up the steps of the Capitol, crawling up the steps of the Capitol, to be able to talk about how important their rights were. We were talking earlier about there are so many people that were instrumental. Justin Dart went to every single state twice to rally support of people with disabilities, to educate those with disabilities about what the potential of the ADA was. And that was really a critical factor, getting people with disabilities to tell their story. I remember part of the campaign to get the ADA passed was to send diaries, a day-to-day diary of what your life was like. You know, I couldn't go to the grocery store because the grocery store had 2 steps. Or when I got in, there was nothing I could reach because it was all above my head. I couldn't get through the checkout stands because they were too narrow. People who were deaf were never offered interpreters and were struggling to make telephone calls. There were volunteer telephone operators that would relay calls to their doctors or to Pizza Hut to get a pizza. There were so many aspects that people with disabilities, in learning about what the potential of the ADA could be, rallied behind the passage of the ADA and made a tremendous difference in making sure that their voices was heard. And I think that is one of the most exciting things to think about when you look at the power of people and the power of people with disabilities, as we've seen since then, being able to advocate for themselves. And I think that's one of the legacies now of the ADA, is that people with disabilities have a right and a responsibility, much like those who spent hours and days protesting to get buses accessible with ADAPT, or marching in the streets, or doing sit-ins, making sure that their rights were protected, and this new revolutionary law called the ADA would come to pass.
I'd like to follow up on that, especially Justin Dart's work in going to every state and having these diaries. These diaries became very important. Not only did they rally the disability community together in a cross-disability way, but it changed the idea of the invisibility of the disability community. What was written in those diaries, the problems people faced in their everyday life, Justin brought these diaries when he testified before Congress, and he gave them to Congress. They became part of the legislative history of this law, and they were very powerful because it spoke to the members of Congress about the difficulties that people face because of the barriers in their environment, or because of the attitudes that existed because of the isolation and segregation of people with disabilities. So these diaries became a very important part of getting the word of people with disabilities out. Since we're talking, Justin was an important part of this. Another person who was known as the General at that time, Pat Wright, who was at that point in DREDF, the Disability Rights Education Defense Fund, mobilized the disability community together into a cohesive force. So that it was incredible to see the organization that was there in the disability community. I'll give you one example. Another person who was working at that point was Liz Savage, who at that point was, I don't know if at that point she was at DREDF or the Epilepsy Foundation, but was a key part. So we would, one day we were meeting in the morning with a congressman, and he expressed some difficulty with some parts of the legislation we were considering. By that afternoon, Liz, through her network, had contacted people in that congressman's district who called his office and said, here are the ways we can deal with that. This is why we need this language. This is why we need that. That was very instructive in a couple ways. It showed a member of Congress that this was a force of people to be reckoned with. They were organized, and they got the information available. So it was and another part of that was the independent living movement that was in full force at this time, which was a very important part of mobilizing the disability community to have their voices be heard. So we were, we were involved in this. I should also point out, at that point, I was working in the Justice Department. The Attorney General of the United States was Dick Thornburgh, who was a Republican, himself was a parent of a child with a disability, so he understood the issues confronting people with disabilities firsthand. His wife Ginny is still a disability rights activist, but he was also had been a governor of the state of Pennsylvania, so he understood the difficulties that states confronted. So he was in a very good position to understand all aspects of this and to be a point person for the administration, and he was the point person. His testimony, there was a bill being introduced. Senator Harkin, Senator Kennedy had come to the administration and said, okay, Mr. President, when you were campaigning, you said you were for a civil rights bill. How about this one? And what was the administration going to do? Remember, it was this bill was pretty revolutionary. How do you come to terms with that? And Dick Thornburgh played a key role in marshaling the administration and getting them to support what became the ADA. And there were a couple compromises on some issues, but not on others, that became important. And there was a long series of negotiations between the administration, the disability community, members of Congress. I think one of the important things that came about was extensive coverage of Title III, which is public accommodations. There were a number of people in the administration who wanted to narrow that down. They didn't want it to be expansive, or they wanted to have a size limitation or a grandfather clause. There are still people who think there's a grandfather clause in the ADA. There is not. I think someone in the ADA National Network, someone once told me the ADA doesn't have a grandfather, it was adopted. I love that phrase. But it's important to know there is no size limitation or grandfather clause in Title III that deals with public accommodations, the businesses that serve the public. And the reason for that is statistical analysis showed that if you had one of those, it would decimate the coverage of the ADA because most of these businesses are small. And so that was an important feature that got included in the ADA. But there were some cost issues that were worrying members of Congress and worrying the administration, and so there are limitations built into the ADA. They came from Section 504. Nothing that would create undue burdens, which for Title I, the employment section, was defined as significant difficulty or expense, or nothing that would result in a fundamental alteration in the nature of a program. These were concepts that were in 504, had been there, and I think people were comfortable with those. It was also important to note there was no cost limitation when it came to the requirement that all new construction had to be accessible. And why is this? Studies showed that making a new building accessible didn't cost very much more. You know, if you design a door to be wide enough, it doesn't cost more than designing a door that is a barrier. And so there is no cost limitation on the requirement that every building built after 1992 in this country that is covered by the ADA is supposed to be accessible according to the standards developed by the government. The other feature that was important was the ability of people with disabilities to be able to go to court on their own. If we're really talking about having rights as a citizen, you have to be able to use litigation as your tool. And that was an important part of the ADA that the disability community fought very hard for. The administration compromised on that and said, yes, you can have that, but the hard part is they did not allow for compensatory damages for individuals brought by people with disabilities themselves. However, the Department of Justice, when they brought lawsuits, could get compensatory damages, this is money damages for someone who's been discriminated against, as well as civil penalties. So those were basically the compromises that went back and forth that came about that made, for those of you who study the ADA, it is a complex law to understand. It is very broad in its coverage, but there are limitations on some, and understanding how they work is something that takes some study. But fortunately, the ADA had a couple new ideas, and one of them was that every agency that enforced it had to provide what is called technical assistance, which is public information about how to comply, what compliance is. It also, in a separate piece of legislation, established the ADA National Network, our sponsor today for this session. And Marian is someone who can speak eloquently about what that meant. And I think one of the features that made the ADA as successful as it is the technical assistance ADA information requirements of the ADA, requiring not only those who enforce it, but others to provide information on how to comply.
Absolutely. I think the ADA National Network, in conjunction with the federal agencies, became great partners in able to provide the technical assistance necessary to make sure this law was effective. As John's indicated, it was incredibly broad. We have employers who never had requirements to hire people with disabilities and accommodate them. We had state and local governments who never received federal funds that would tie them to Section 504. Private businesses were never required to provide access and services to people with disabilities in the broad basis that the ADA mandated, as well as telecommunications and others. So there was a huge demand for information and for one-on-one discussion. Luckily, powers that be decided that there should be 10 independent centers throughout the country in the different regions that would reach out and provide free technical assistance on the phone, in-person training, remote trainings like we're doing today. And that's been happening now for a little over 28 years in providing this really valuable service, we think, in making sure that the ADA became real, not only to covered entities, but very often to people with disabilities and their families and friends that interact with them on a daily basis. So the ADA National Network would work in developing coalitions, developing grassroots strategies, making sure people with disabilities understood their rights and responsibilities, working with the employer groups, working with the Society for Human Resource Management, other employment organizations and unions, talking about what it meant to include people with disabilities into the workforce. We did a massive outreach and face-to-face trainings, going on site, making sure people had their questions answered. Many of the questions, as you might imagine, continue to be fairly nuanced, and it's on a one-to-one basis. It's confidential. The teleconferences are free, so that people really hopefully get the kind of information they need. The national network developed a lot of information in plain English, many times translating a little bit about what the federal regulations were, or some of the larger technical assistance documents that the Department of Justice, EEOC, Department of Transportation, and others developed, the Access Board, in helping lay people to really understand what the legal language is and what it meant in more common vernacular. So one of the things that I think the ADA National Network has done a good job of is translation of the ADA into practical application, practical knowledge about how to move forward, what rights and responsibilities are, making sure that people understood their choices. As we all know, the ADA is not hard and fast many times, but there's a lot of options that people can take. And we want to make sure that people know that range and be able to feel informed enough to go out and act on that, and to be able to change the attitudes and the concepts around people with disabilities being part of full inclusion within the American economy and the American workforce. So we feel, being somewhat biased, that the ADA National Network continues to be a significant player in the enforcement to date and the application, not only the letter of the law, but really the spirit of the law, talking about the importance of including people with disabilities into the mainstream of society, where there's great benefit in having people with disabilities work, play, recreate, shop with everyone else.
Another feature that since we're talking about the passage of the ADA, at the same time there was a lot of concern in Congress about the costs, and the costs were going to be borne by employers that would have to do reasonable accommodation, by businesses that would have to remove existing architectural barriers, provide sign language interpreters, provide materials in alternate formats, and so they would be incurring costs. And there were no federal funds, per se, that were going to help them. So the idea became that we would amend, and Congress did amend the tax code when it passed the ADA to give, there were two, a tax credit that would help small businesses, and small business was defined pretty, you could have up to $1 million or up to 100 employees, and you were still a small business and could get a tax credit for changes that you made required by the ADA each year. So the idea behind that was, although the business would have to expend money for a sign language interpreter or putting in a ramp or making its restroom accessible, it could take and get a tax credit, thereby putting some of the burden on the whole population through the tax code. I think that was a very important part. It was very underused at the beginning. I think the Justice Department and the ADA National Network had spent a lot of time explaining to businesses that they could get this tax credit or a tax deduction as well for changes that they made. Very important part of this, and it defuses the argument that, you know, we can't do this. We don't have the money to do this. The other part that became important was, you know, this wasn't a one-time obligation. The ADA was passed and you either did it or you didn't do it. It's a continuing obligation. So a business might have a lean year and couldn't do everything that they wanted to do the first year, but over a period of time, they would have the resources to remove existing architectural barriers or to provide sign language interpreters or materials on tape. Now we'll get to websites and making those changes, but as times change, there are other ways to make a business accessible, and the tax credits are there for entities, and the information is there to make the changes that they need.
Absolutely.
Let's go to, all right, the ADA is passed.
All right. So the next slide is slide 17 or 18.
Oh, wonderful. You
18.
Want to talk about this day?
The signing of the ADA. Both John and I were there, and really, it's one of the highlights of my life.
And mine too.
Much like today here in the DC area, hot and steamy.
Yes.
And it was the most incredible, as you can see from the picture here, thousands and thousands of people on the White House lawn. As far as I know, it's the largest signing of any bill to date because there were so many people invested. People were invited from all over the country to participate. I have never seen so many people with so many different kinds of disabilities all in one place celebrating. I really thought of it as the 4th of July for people with disabilities. It was the beginning of our civil rights. It was the declaration that we did truly have the rights and responsibilities to be able to work, to be able to interact with government, to be able to go to places, to be able to listen and hear and move as we needed to. And all of these people were there to celebrate and to see something historic. And it's something I will never forget, just that sheer passion that everyone had. Let the shameful walls come tumbling down. It was truly a magnificent day in the lives of many people with disabilities. And I really hope as we continue to look forward to the ADA and its potential that younger people will still be able to appreciate the significance as they live with the ADA of this monumental day when Congress almost unanimously passed this, at times, rather controversial bill that talks about the rights of people with disabilities. I remember hearing congressmen say, that you're a citizen, you have all the rights. It's like, no, I don't. I may have the rights, but I have the inability to do what I need to do when I want to do it. So it was this huge effort across all 50 states to be able to get people rallied around to assure that happened. And then this celebration, and it happened very quickly. I think within about 3 weeks, you had all these people amassing into Washington to be able to see this historic signing.
It was a great day. I also had some other worries about this day, which because there were a lot of requirements placed on the Department of Justice. I was an employee of the Department of Justice, and Dick Thornburg, who had been the key point person in getting the ADA passed through the administration, was now the person who was responsible for getting regulations out. And I think justice learned from the lack of enforcement from 504 and the idea that there would need to be a focal point, so there needed to be an office. And so what happened at Justice is they created a unit. It began as the Office on the Americans with Disabilities Act, and at the beginning that was me and my secretary. It pretty quickly expanded beyond that. We became the public access section, and later on we became what you now know as the disability rights section under Janet Reno, because no one knew what the public access section was. But we were charged with coming up with, we had a year to write a regulation. Sounds like a lot of time. It certainly did, and to come up with the standards for what is an accessible facility. And the way the law was written, the Access Board had to come up with guidelines, and then the Department of Justice had to come up with standards that conform to those guidelines. We had to do that in a year period. We also had to issue a technical assistance manual for both Title II and Title III, explaining in plain English terms, was the idea, what the ADA meant. So the onus was on us. We also had to set up a technical assistance program because that was required. So there were a number of things that we had to do in the first year. And we had limited resources, more than 2 people, but we had limited resources. So how did we approach that? I think it's, our idea was to give full meaning to the new law with the resources that we had. That meant having extensive coverage. We wanted to ensure there was full relief, that we used litigation, that we used technical assistance. There was a requirement for the certification of state and local building codes in the ADA. There were a lot of activities that we began. We also were in the process of hiring people to do some of these activities. We were fortunate to be given the ability to hire 10 people, which was a huge change for us to do that. We were trying to balance big cases with small cases, give meaning to individual complaints, review complaints. If there were attempt to get voluntary compliance where people wouldn't do voluntary compliance, use our ability to sue. All of those were our activity, but overriding part of our goal was to build support for the ADA. This was a new law. We wanted the public to understand it. We wanted to keep it, our focus on fundamental issues. We wanted to stay away from frivolous things because we wanted to give meaning to what this law is. And so that was what we did at the beginning. I've said this before, I love this. On the first day after the ADA was enacted, we got an idea of why there needed to be public education, why we needed the ADA National Network, why we needed a justice to have the ADA information line that we established. We got a call from a hotel in North Carolina on the day after the law was passed, and he said, "Did you people up there pass some law about people with disabilities?" And we said, "Yes, we did. Why are you asking?" And he said, "Well, a person in a wheelchair came to my hotel last night and said there was a law that gave that person civil rights, and they were entitled to the best room at the cheapest price." I took a breath for a minute and said, "Well, what did you do?" He said, "Well, I gave them the best room at the cheapest price." Now, of course, that's not what the ADA did require, that there be accessible rooms and a choice of accessible rooms for a person with a disability. And so it pointed out the need for education for businesses and for the education for people with disabilities. So what was our goal? Our goal, we started getting flooded with complaints. We used those complaints to see what people with disabilities thought were important. And we tried to balance big issues with small issues, precedential issues. Issues that caught the public eye. One of our first cases was making the Empire State Building accessible. It's a symbol of the United States. And we did through negotiations, and we're talking about taking an elevator to the observation deck. And one of the things that wasn't accessible was there was no place for a wheelchair user to look out. And so we told them they would have to drill, take some of that down. Now, they said it was, that's an architectural landmark. We can't do that. And we looked at it and said, I think you can preserve the architectural landmark and still cut out a place so that wheelchair users can have a view. One of my favorite things, Saturday Night Live, a TV show that I think you all probably know, had in their weekly update a comment, and they had a picture, and they said, "This week the government made the Empire State Building be accessible. The ramp starts in New Jersey, goes across the river," and I had this very picture, which was a great idea for us because it got the idea out that this law was going to be enforced, and it was important, and it covered a lot of things, including, what we do every day as citizens. But we also balanced that with, we started getting a lot of complaints from people who are deaf, blind people who couldn't be jurors, deaf people who were having difficulty at hospitals, not having interpreters. These were a lot of the blind people who were taking the SAT but couldn't get the exam in accessible formats. These were a lot of the early cases that we concentrated on. A lot of them were barriers in restaurants, inaccessible parking, barriers at shopping malls. Those were the early activities, and things that you might not even think about. We had a case, check cashing. in order to cash a check at a department store, you needed to have a driver's license. Well, a blind person couldn't have a driver's license, so they wouldn't allow them to pay by check. So we had to say, well, no, a state-issued ID is the same as a driver's license. So it was very elemental stuff at the beginning, and our technical assistance efforts were very elemental, explaining what an architectural barrier is, what you have to do to make it accessible. The 911 system not being accessible to users who are deaf was, I think in the early years we had over 500 settlement agreements with local governments trying to make their systems accessible. So that's an idea of the kinds of cases that we were working on at that point.
I think the ADA National Network also found a lot of reasonable accommodation cases that we would get under the employment provisions. Many employers and people with disabilities really didn't understand the requirements of the Title I provisions, talking about how to accommodate a person with a disability, making sure they knew that there were tax credits and deductions they could be using, but also the practical application. And the ADA National Network, in addition with work with the Job Accommodation Network, where we partnered, talked to a lot of employers and workers with disabilities about what the law talked about and how it could be done efficiently and effectively, what kind of accommodations could be made, helping people think outside the box and how to accommodate individuals with disabilities, reminding them to go back and talk to the person, find out what resources are around in their community. And as assistive technology became more and more a player, became much cheaper and readily achievable for many people with disabilities to be accommodated in the workforce. We had a lot of calls from people saying, where do I hang the grab bars? We're getting ready to do it right now. How do I do a 1 in 12 ramp? How do I do any number of things? So we found that we were providing a lot of the really nitty-gritty on a day-to-day basis to practitioners in order to make sure that they understood what their requirements were in order to assure full compliance.
Okay, before we get to talk about the future of the ADA, I'd like to at least talk about some of the things that I think are the success of the ADA over this 29-year period. And I think a lot of them deal with the physical environment that we're in. I mean, I think if you look at accessibility today versus when we started this process, it is a very different country that we live in. We have town halls and city services that are accessible, sports arenas, movie theaters, courtrooms, hotels, restrooms, shopping malls are accessible. Our transportation system, especially our city buses, in our cities are now 100% accessible, because the requirement of the ADA was not to retrofit existing buses, but when a city replaced a bus, it had to get an accessible bus. And so, since the useful life of a bus is 10 to 15 years, over this period of time, we now have fully accessible city bus fleets. In education, the the Individuals with Disabilities Education Act, that a free, appropriate public education is required for all students with disabilities, no matter how severe their disability. Every child with a disability can learn and is entitled to learn with an educational approach that meets their needs. As one of the major changes I think I've seen if you look at the most recent statistics for our colleges and universities, over 12% of the students in our colleges and universities are now students with disabilities. When we began, there were very few, and that really speaks to the future for me. The use of sign language interpreters in courts, in doctors' offices and hospitals, and with the police is a changed system. Service animals are now welcome most of the time, although I would say one of the surprises for me over this 29 years is the number of questions that we still get about service animals in our public accommodations. the Olmsted decision in 1999, I hope all of you know what that is, but the idea that the unnecessary institutionalization of people with disabilities in separate institutions is in and of itself a violation of the ADA. This is this decision, which we just celebrated its 20th anniversary, is a work in progress. We are still undoing our segregated system, but we are working at it, and it is one of our works in progress. The idea of reasonable accommodation and the information that EEOC has provided over the years about how to accommodate people with disabilities, with a wide variety of disabilities in the workplace, is very important. I think the difficulty we faced in the employment area was the terrible line of decisions limiting the definition of who is covered by a person as a person with a disability under the law. We had a series of terrible, in my view, decisions that misapplied what I think were the standards of the ADA, but the good news is in 2008 in the ADA Amendments Act, we went back to what is an expanded definition of a person with a disability that befits a civil rights law. A civil rights law should be cover all people with disabilities, from those with HIV, with those with psychiatric and psychosocial conditions, those with intellectual disabilities, those with physical disabilities, across a wide range.
I think that the ADA Amendments Act really did a huge shift change for the ADA. Because we were slowly eliminating many people with disabilities. And I think it reinvigorated the community in talking about employment as being such a critical factor. Even today, employment still is a huge challenge. And that change at least brought the employment provisions back to the forefront and got us moving, I think re-energizing both the employment community and people with disabilities in focusing on the employment provisions. And then some of the new regulations that came out after that, that continue to grow. One of the things I think is most exciting about the ADA is that it's living and breathing. As technology changes, as the need changes, we're seeing more and more accommodations being made and more regulations coming out talking about standards and the inclusion of people with all different kinds of disabilities by looking at the technology that exists and some of the continued challenges we have in that arena.
And since we're on challenges and we want to get to questions in a few minutes, let's talk a bit about the future.
Okay, we'll change to the next slide.
And I'll start us off with my view of one of the most difficult things is still the continued unemployment or underemployment of people with disabilities. The statistics show that approximately 1/3 of working age people with disabilities are employed, but if you compare that to the able-bodied population, it's half. 2/3 of able-bodied people are employed. So we still have a long way to go to get people jobs, to get them employed at full pay, not less than the minimum wage for the jobs that they are in. And I think we are making change. The future is bright here, but it is work in progress. There are ways that we have to do this in terms of training and mentorship and rooting out discrimination. It may be that we have to, since most new jobs are with employers that have fewer than 15 employees, and the ADA only covers employers with more than 15, perhaps that is something to address in the future as a statutory change. But I think employment remains one of the most difficult problems that, and some of it is tied to the ability to have health insurance and giving up your Medicaid coverage if you get employed. I mean, and we've worked on that issue, but the unemployment issue is, I think, one of the large issues on our agenda for the future.
I totally agree. I think it's the hugest obstacle that we have. One of the other things that I feel so important about are the stigma of mental health is still incredibly prevalent, and the access to mental health services for folks who are deaf, making sure that we've got appropriate sign language available. The stigma that exists saying that you can't possibly work if you have a mental illness, that if you do so that you're a risk, that you're a threat to your coworkers. All of those issues are huge, and I think that is going to be a growing issue under the ADA.
Yeah, and I think a piece of that are young people in our country with mental health issues, and the lack of services for them is a contributing factor. And tying to that, students who are in elementary and secondary education institutions who may have IEPs that aren't really being fully funded or are not being dealt with, and the whole school to prison pipeline. What happens is, the student drops out, or they are suspended, or they are sent to juvenile detention centers, and lead to really a life of lack of services and the inability to be employed. Into prisons I think we have recognized this as a problem. The education department has taken some steps. We all have taken some steps, but this is another. We have to invest the money when these children are children and teenagers, get them the right services and training so that we're not spending huge amounts of money in our prison system to keep them segregated from our society.
I think one of the growing trends we're seeing in the ADA, but still a huge barrier, is access to medical care for people with disabilities, both the physical setting and the ability to use existing equipment, getting on tables, getting the right kinds of supports needed in order to get the services that people with disabilities. And it's complex. It's getting the transportation to and from, it's training staff, it's getting the awareness, but a lot of it is the technology, having lower tables, having the technology that will adjust to people with disabilities as opposed to have them adjust.
And I should point out that I hope you all realize that the Access Board, under a separate law, has issued at the end of within the last 2 years standards for what is accessible diagnostic equipment. Unfortunately, there is no regulation by Justice or by other federal agencies that require those standards to be followed. But that is a next step. Unfortunately, this administration doesn't believe in the regulatory process to the same extent that those of us in the past have, and there is no movement at the present time to issue new regulations that would require hospitals, doctors' offices, other medical providers to have accessible equipment. Of course, they should have that. There are standards that are in place, but there are difficult issues. It's not just the equipment, it's how they're placed, how they are used, how people are trained to use them. It's a complicated issue, and it requires action by the federal government to provide information that will not be forthcoming in the immediate future, unfortunately.
Sure.
And while we're on that issue, let's talk about the accessible technology. We live in a different world than we lived in even 30 years ago. We live in a digital world in many ways. How we get our services, how we interact with one another, we do on websites, we use apps. Ensuring that they are accessible is a very important part of the ADA. Of course, when the ADA was enacted, the internet didn't exist as we know it. There are those who say the ADA therefore doesn't apply to the digital world. I disagree with that personally, and the federal government has disagreed with that. I think the first statement came in 1996 from the Department of Justice. There have been a number of settlement agreements that the Department of Justice has been involved with. There's been private litigation. The National Federation of the Blind has done amazing work in bringing this issue to the fore through litigation. But I think, unfortunately, the federal government in 2010 started the process of moving toward having regulations that addressed accessible technology, requiring it for the ADA. The Trump administration has pulled back on these regulations and does not have it on the regulatory agenda to move forward during this period of time. I think that is a mistake, and we should reconsider that, but that won't happen. But that doesn't mean that technology should not be accessible. If you look at the litigation, there's a huge amount of litigation going on under Title III in our country, and it may reach the Supreme Court. The Robles versus Domino's case in the Ninth Circuit is one that we will keep an eye on. It may make it to the Supreme Court, but the Ninth Circuit has said certainly that that the ADA does apply to websites that were used to order a pizza there. How that will turn out remains to be seen, but I think this is a cutting-edge issue. But if the ADA is about achieving equal opportunity, self-sufficiency for people with disabilities. In our digital world, that is part of what everyday American life is. I think the ADA covers that. That is one of the challenges on our plate right now.
I think as we wrap up the future, I think the future of the ADA is the ADA generation, folks like Megan and others, taking up the mantle, going from this basis, this good, solid basis, but expanding the horizons of the ADA and other civil rights legislation. Lots of talented, really incredible young people, knowing what their rights and responsibilities are, looking at new barriers and what can be done, taking the mantle and running forward with it. And we see tremendous energy within them. And that brings me hope that the ADA will live on and grow as other rights and responsibilities for people with disabilities continue to be enhanced.
Let me just conclude by agreeing wholeheartedly that I think that the idea of this ADA generation, this group of people with disabilities who were born after the ADA, and who are not going to go back to what we talked about before. They are not going to be second-class citizens. There's a whole looking at the whole range of people with disabilities, the idea of intersectionality, the idea that there are people of color who are also disabled, people whose language is other than English and who have disabilities, and looking at the total person and their rights as a person in our society and how we come to grips with that, both in the leadership of the government and of the disability rights organizations. But dealing with these issues, I think the future, the energy that's coming from that, the change that will take us into the future is, I'm very optimistic.
You turn it back to Megan.
Okay, thank you. So we'd like to ask the audience to open up some questions.
Okay.
Right. If passed, what effects would HR 620 have on the ADA?
Okay, I'll start. Let me start with the if passed. No, we're not going to have it passed. But let me tell you, 620 is a piece of legislation that was passed by the House of Representatives in the last Congress, and it was an attempt to restrict the ability of people with disabilities to file lawsuits against public accommodations on the issue of barriers, physical barriers, unless they first gave notice to the entity and the entity had 60 days or 90 days to try to deal with it, and they didn't even have to remove the barriers. They had to start and make a credible effort to do it. I think it was a weakening of the ADA, and the question was, if passed, what effect would it have? I think it would have a a very large impact, because the ADA, really relies on voluntary compliance. It relies on the goodwill of businesses to comply with what the laws of the United States are. We have seen over the past 29 years, businesses take what we call the wait-and-see attitude. We're not going to remove barriers. That's going to cost money. We're not going to do that. We're going to wait until someone sues us. That wait-to-see attitude would be encouraged by a law like 620, which is doesn't even address the issue that members of Congress hope that it would. There are those who think there are too many ADA lawsuits. I am not one of those. There are 3,000 to 5,000 or 6,000 lawsuits every year under Title III of the ADA. Even if you look at the president in his ADA proclamation this week said there are 61 million people with disabilities in this country. There are 27,000 units of state and local government. There are 7 million public accommodations. If you put all of those interactions together, that number of lawsuits is very small. I do not think we have a problem with too many lawsuits. I think a problem that people with disabilities face is facing barriers and not having a way to get them removed. And 620 will take away the need for a business to comply with the ADA until someone comes to them.
And it's the only proposal that would say that as a civil right, you have to wait until you give someone notice before you can do anything about it, and that's unacceptable.
I should also point out, I don't think a bill has been introduced yet in this Congress. I think we have heard from members of Congress. The unfortunate part, there was some bipartisan support for 620. There were some Democrats a few Democrats who supported it along with the Republicans, but I think that we have heard from at least this House of Representatives that bill will not move forward in this Congress. That doesn't mean it won't come up again in the future, and I think we have to be vigilant. I think one thing that people need, if there really is a problem with people not understanding, we need more education. In the early days of the ADA, there was a lot of money for training people with disabilities, for giving money to businesses to understand the ADA. Maybe instead of 620, we need funds that go to federal agencies, more money to the ADA National Network to get more information to people so they know how to comply.
I agree.
Another question.
Next question. Have there been any height requirements adopted for beds in accessible hotel guest rooms?
I'll start. One of my regrets is that I couldn't get this done while I was still in the federal government. There are no, the easy answer is there is no regulation written by a federal agency that said that. However, there has been a lot of action by people with disabilities and their organizations to address the idea that, and I think some hotel chains are beginning now to deal with this on their own based on pressure from disability rights organizations. For those of you who might not know, the idea is that our hotel beds are getting taller and taller, and for many wheelchair users, it's now an Olympic event to try to get into their bed and out of their bed in a hotel room in the accessible room. There have been some studies showing what the accessible height should be for an accessible bed, which has some give in it for the range of a wheelchair user. I think the idea of 17 to 9 inches is too low, because once you're in that bed, you could never get back to your wheelchair. I think 22 to 23 inches is the idea, but there is nothing that I know that has put any of that in a requirement yet, although every time I talk to a hotel chain, I raise this issue because I have too many friends who cannot, who when they get to a hotel room have to have the people come up and take the mattress off, change it so that they can use the accessible room.
Right, take the
Have you?
off.
Yeah.
But we are seeing that some of the major chains are aggressively looking at their new bed designs in order to make them more accessible, because they're starting to get complaints not only from people with disabilities, but others, saying that they're tired of catapulting into bed.
Next question.
What is the status of guidelines for accessibility in public rights-of-way?
This is the Access Board has been working on the public rights-of-way guidelines for a long time. They were very close to coming to them, but they did not get them approved in the last administration. This administration has a different approach to its regulatory process, and so at the present time there is no movement to issue those public rights-of-way guidelines. One reason for that is that there is an executive order that the president has issued that said if you want to issue a new regulation, you have to get rid of 2 existing regulations. So for the Access Board to do that, they would have to get rid of 2 existing guidelines, and that is an inappropriate way to develop the standards, the guidelines and standards that are needed. So I think in the foreseeable future, you will not see guidance on public rights-of-way.
Next question. Are there any courses that I can take as a full-time wheelchair user with CP to deepen my knowledge of the ADA?
Oh, what a great question. Yes, there are. If you go to www.adata.org, you will find a plethora of information. There is an ADA course. There are webinars that are recorded and you can take all for free. I applaud you for wanting to learn more about your rights and responsibilities under the ADA. So I really encourage you to check out the many resources that you'll find under the ADA National Network's website. I also encourage you to connect with your local ADA center. At adata.org, you'll find the link to your region by going to the map and clicking on it. I would encourage you to connect with your regional ADA center, find out what's going on, what they're sponsoring, and work with them as well to be able to enhance your knowledge around the ADA.
Okay, here's the next question. Can you address the service dog Wodatch misrepresentation and whether ADA is looking at making changes to the service animal law?
I'll take first of all, keep in mind that under this administration, I don't think you will see any ADA regulations in the next 2 years. I mean, the administration has made very clear that they think that the government has overregulated business, so there's not going to be more. A number of states have put in place laws that make it a violation of state law, sometimes the criminal code, to misrepresent that you have an animal as a service animal. I think there's over half the states now have laws that say that. I'm not familiar with them being enforced. I know that they are there. But I don't think you will see any change at the federal level dealing with that issue.
Next question.
The next question is, where can I find resources for training staff on all aspects of the ADA?
Oh, there's a plethora. On the ADA National Networks, adata.org, you'll find a lot of information about self-courses, training materials and resources, the Job Accommodation Network, Also has a tremendous amount of information on the employment provisions, and there's modules and training courses that you can take there. You can call your regional ADA center and talk with them about getting a customized training to your business and your needs. So there's lots of resources out there. It'll take one phone call to 1-800-949-4232, voice or TTY, to be able to explore what your specific needs are and what those resources are.
Also, there are the agencies that enforce these laws have a lot of documents on their websites. EEOC has an incredible wealth of information on their requirements on reasonable accommodation. There's a lot of information there. The Department of Transportation has a lot of information on accessible transportation requirements of all forms, and the Department of Justice at ada.gov has a number of documents explaining specific issues like service animals, voting accessibility, Olmstead issues, HIV issues, and the Access Board, if you're interested, has a wealth of incredibly good information on how to make a wide range of facilities accessible. There is plenty of information available for you.
Absolutely.
Next question. How can I file complaints under the ADA?
Yes.
I'll say, well, it depends which title you're going to file under, but if you are going to file a Title I, if you're filing an employment complaint, you would file it with the EEOC. You can do these things online, or you can do them by by going online and getting the address of the EEOC local offices. You can send it on, if it's against the state or local government or a public accommodation, you can file a complaint with the Department of Justice by going to ada.gov and getting the information there. You can also file complaints with other federal agencies if you have a relationship with them. So, for example, if it's against a college or university, you can file it with the Department of Education. If it's an agricultural funded service program, you can file it with the Department of Agriculture. The important thing to do with a complaint is to file it quickly, because there are time constraints, usually 180 days from the act of discrimination. The important thing is to get it into the federal system. If you don't get it to the right place, the federal agencies have a responsibility to help you and get it to the right place.
And don't forget that you have similar rights in many states and localities that parallel the ADA, so that you can file with your state Human Relations Commission and other entities within your state and local government. So take advantage of those resources as well.
Okay, so that's all the time we have today. This concludes today's webinar. We realize that many of you may still have questions. We apologize if you did not get a chance to ask a question. Please contact your regional ADA Center for follow-up questions at 1-800-949-4232. We want to thank John and Marian for sharing their time and knowledge with us. I think that everyone learned from today's webinar. Thank you for joining us, and have a good day.